Offer in place. Okay. Okay, so I will now bring the regular meeting for the purpose of a public hearing for the Township of Lanning to order. And the first item I have to do is to read the preamble, the beginning of the agenda. A public hearing is a statutory requirement under Section 464 of the Local Government Act and must be held before third reading of a community plan, rural land use bylaw, zoning bylaw, land use contract amendment bylaw, heritage designation bylaw, or heritage revitalization agreement bylaw, which would change the use or density of use of property. During a public hearing, council acts in a quasi-judicial role for the purpose of allowing persons who believe their interest in property is affected by a bylaw, permit, or other matter to make representations to council either orally or by written submission, or add comments or elaborate upon correspondence that may have already been presented to council concerning the bylaws. It is important to note that council is not in a position to receive any additional information on the bylaws following the public hearing as dictated by case law. The hearing procedure involves an explanation from the Community Development Division on the purpose of the proposed bylaws and to hear from individuals regarding the bylaws. In order to ensure that all interested parties have a reasonable opportunity to be heard, speakers are requested to keep representations as brief and succinct as possible and no longer than 5 minutes, excluding time required for questions from council. Speakers will be asked to state their name, neighborhood, and city for the record, and if referring to prepared remarks, to submit copies of these to the Township Clerk. Decorum must be maintained at all times. This includes refraining from applause, booing, or heckling. To assist with large numbers of speakers, the individuals may advise the Township Clerk and sign the speakers list prior to the commencement of the public hearing. The names on the speakers list will be read out during the hearing. However, the chair will also call for any other speakers wishing to present their views once the speakers on the list have all been heard. Individuals who've already addressed council and wish to add further submissions will wait until the people that have not yet addressed council have had an opportunity to speak. All submissions and speakers lists are considered part of the public record. Council members should not express their views nor debate the bylaws, but may question speakers to clarify particular points in the submissions. Council may consider third reading or third and final adoption at this meeting or at its next regular meeting to be held on Monday, November the 23rd in the Fraser River Presentation Theatre, 4th floor of 20338 65th Avenue, Langley, BC. So with that, I would ask for a motion to adopt and receive the agenda items. Councillor Kunst, Councillor Whitmarsh seconds. All those in favor? Opposed? And that carries. Thank you. So we now move on to bylaws for first, second, and third reading. And B1 is highway closure, dedication, removal, and disposal. Bylaw 5637. Could I have a motion, please?
So moved.
Councillor Long, second by Councillor Kunst. Any discussion? Seeing none, I'll call the question. All those in favor?
Aye.
Opposed? Carries unanimously. Move on to B2. This is highway closure, dedication, removal, and disposal. Hayhurst, bylaw 5649. Could I have a motion, please?
So moved.
Councillor Davis, second.
Second, Ferguson.
Councillor Ferguson, discussion. Seeing none, call the question. All those in favor?
Aye.
Opposed? That carries. Thank you. B3 is highway closure, dedication, removal, and disposal. Zenterra, bylaw 5638. Could I have a motion, please? Councillor Whitmarsh, second by Councillor Kunst. Discussion. Seeing none, I'll call a question. All those in favor?
Aye.
Opposed? Carries unanimously. There are no development permits. We move to the public hearing. And there are two public hearings. The first public hearing is D1, official community plan amendment and rezoning application number 100203, development permit application number 101012. This is at 20443 70 Avenue and 7010204 Street. It's bylaw 5626 and 5627. Mr. Richardson.
Thank you, Your Worship. With your permission, I'll share the screen. So thank you, Your Worship. The subject Central Gordon Neighborhood Plan Amendment, rezoning, and development permit applications pertain to a proposed development consisting of one 5-story mixed-use building with 11,064 square feet of ground floor commercial space and two 4-story apartment buildings accommodating a total of 135 apartment units at 20443 70th Avenue and 7010204 Street. 2.3 acre site is designated multifamily and neighborhood commercial in the Willoughby Community Plan, and apartment, mixed use, and green link in the Central Gordon Estate Neighborhood Plan. This air photo depicts the site located on the northeast corner of 204th Street, 70th Avenue. Proposed Central Gordon Estate Neighborhood Plan Amendment Bylaw 5626 will increase the maximum permitted commercial area by 2,150 square feet. Proposed rezoning bylaw 5627 amends the existing suburban residential 2 zoning, comprehensive development zone 151 to accommodate the proposal. This slide indicates the proposed site plan, noting the 3 proposed buildings with vehicular access from 70th Avenue. Next series of slides are renderings, elevations, and landscape plan is noted in development permit 101012. Staff recommends support of Central Gordon Estate Neighborhood Plan Amendment Bylaw 5626 and rezoning bylaw 5627, subject to 13 conditions and issuance of development permit 101012, subject to 6 conditions. It's on page 10 of council's agenda. Your worship, a total of 48 notices are mailed out. 1 written submission has been received. And there's 1 individual noted on the speakers list, Wayne Yang.
Thank you. So I'd ask it was Mr. Wayne Yang.
I have
Hang
one.
on, hang on 2 seconds.
If you could come forward, thank you.
I have two questions. My
So,
friends.
sorry, if you could provide your name
Oh,
and
my
where
name
you live.
My name is Wei
first.
Yan. Yeah, my friend is Jamie Xu. She lives in 7080 204 Street. So she wants to know right now is for zoning. So his house 7080 is together with 7058 and 7042, right? Together. So it's possible to separate develop this. The house, so it can separate, develop it or not.
Okay, so we aren't here to answer your questions. We're here to hear your submissions if you have any concerns regarding the bylaw. So if you want to provide us with your concerns, then that's helpful to council. So do you have any concerns either for or against this development?
I mean, it's possible to develop it separately, not together with another two houses. It's possible or not?
Well, that'd be something for staff to respond to another time. But right now, so are you saying you don't want to separate it, or you do want it separated?
Yeah, I just want to know it's possible to separate. Or,
but you're here to present to council your concerns. So you're not here to ask questions.
oh.
Yeah.
So you cannot answer this question?
No, I can't. Because you need to know what the bylaw is and then tell us what your concerns are, either for or against it.
Okay.
Okay.
Another question. Okay. Sure. Another question is about another friend he lives in the 7106. So right now it's zoning to single house.
Yes.
It's possible to rezoning it, to townhouse or apartment.
Yes, that's what this hearing is. This public hearing is to bring council the information, and they will consider the rezoning. So we want to hear your concerns, either for or against.
Okay.
Okay.
That's it. Thank you.
Thank you. Okay, so with that, I'll ask if there are any further submissions regarding bylaws 5626 and 5627, development permit application 101012, which is D1. For a second time, any submissions on D1? For third time, any submissions on D1? Ms. Bauer, are there any, because it's hard to see the waiting room, is there anybody out there that wishes to?
No, I believe there's no more speakers, but the proponent is here.
Okay, does the proponent wish to respond to the questions and concerns of the of the delegate? I'll ask the proponent once if he wishes to respond, second time if he wishes to respond, third time wishes to respond. Ms. Bauer, he doesn't wish to respond. Okay, thank you. So now I'll consider the public hearing D1 to be closed. And in a while, Ms. Bauer, do we look at passing now or wait till the end of the public hearing? Okay, so as council knows, we can move third reading if there is a 2/3 vote of council wishing to do that. So if someone would like to move that we consider third reading at this time. Council Whitmarsh moves it. Is there a seconder?
I'll second
Council
it.
Davis seconds it. So I'm going to call the question. Those who wish to proceed to third reading. All those in favor
Aye.
and opposed? Council Arneson's opposed. That motion carries. So proceed to third reading. So now I would look for a motion to move third reading.
I'll move third reading.
Councilor Whitmarsh moves it. Councilor Long seconds it. Is there a discussion? Councilor Richter.
Sorry, I put my hand up by mistake.
Okay. Seeing no discussion, I'm going to call the question. All those in favor and opposed? Carries unanimously.
Good.
Move on to D2, and this is official community plan amendment and rezoning application number 100178 and development permit application number 101157. Bylaw 5642 and 5643. This is on 18th Avenue. Mr. Richardson.
Thank you, Your Worship. The subject plan amendments, rezoning, and development permit applications pertain to a proposed residential development consisting of 12 single-family lots, 16 semi-detached lots, and 68 townhouse units at 20148, 20152, and 20180 82nd Avenue. The 7.13 acre site is designated residential in the Willoughby Community Plan and single-family residential 3 in the Latimer Neighborhood Plan. This air photo depicts the site located on the south side of 82nd Avenue, west of 202 Street. Bylaw 5642 proposes to redesignate the southern portion of the site to multifamily in the Willoughby Community Plan and Row House Townhouse B in the Latimer Neighborhood Plan to accommodate the 68 proposed townhouse units. Proposed rezoning bylaw 5643 amends the existing suburban residential 2 zoning to residential compact lots RCLA and RCLSD, as well as comprehensive development zone 131 to accommodate the proposal. This slide indicates the proposed site plan with a townhouse on the southerly portion of the site, semi-detached lots fronting proposed 81A Avenue, and single-family lots fronting 82nd Avenue. The next series of slides are renderings, elevations, and the landscape plan is indicated in development permit 101057. Staff recommends support of plan amendment bylaw 5642 and rezoning bylaw 5643, subject to 8 conditions and issuance of development permit 101057, subject to 6 conditions listed on page 8 of council's agenda. Your Worship, a total of 240 notices were mailed out, 16 written submissions have been received, and there were no individuals noted on the speakers list.
Okay, this time I'll ask if there is someone from the public would wish to speak towards bylaw 5642 and bylaw 5643, development permit application 101157 on D2. And I'll ask for a second time if there are any speakers for D2 and a third time for speakers for D2. And I've been told by the clerk there are none. So there's no reason for the proponent to respond unless the proponent wishes to respond to any of the written submissions. Just waiting for. No, okay. So at that point, I'll close public hearing D2, and I would ask if council wishes to consider third reading at this time. Council Davis moves it. Is there a seconder?
Ferguson second.
Council Ferguson seconds. And I'll call the question. All those in favor and opposed?
Opposed.
Council Woodward opposed.
Councilor Richter opposed.
Council Richter opposed. Any other opposed? So it carries to go to third reading. Could I have a motion for third reading for D2?
Move third, Ferguson.
Councilor Ferguson moves third reading. Is there a seconder? Councilor Long seconds it. Discussion, Councilor Woodward.
Yeah, thanks. So I guess I'm a little surprised given the scope of the OCP amendment that we're facing with here. Of course, again, we're in the state of emergency pandemic. I'm not sure we're really getting public input that we would otherwise be getting. So I look at this here on page am I on here? And please excuse me, I wasn't prepared for this necessarily to go to third reading. Page 16 on D2. For those that are interested, I guess not everybody is. So we've got 68 units, that is the 8 to 22 UPA. Certain portion of that, but it's actually designated 6 to 8 UPA, which I just want to make sure I've got the numbers right. Maybe I can get staff to confirm it. The designated for 6 to 8 UPA, now up to, what am I reading here, 13.4. It's an additional density of 42 units. Do you know if I can roughly get that confirmed, Mr. Mayor?
Yes, Mr. Richardson or Mr. Seffi? Mr. Richardson.
Your worship, through the Councilor Woodward, an additional 39.
39. So the math is off there somewhere, so I'll accept that. So for sake of argument, let's go with 39. If I also read this correctly, in exchange for the additional 39 units above the designation, there's been a CAC, additional CAC offered of 431. Is that correct? So that would be 2/3 more than required, because it wasn't clear in the staff report if they're providing the original CAC plus 431 or the required CAC is within the 431. Did I get that clarified?
Yes, Mr. Richardson.
Through your worship, for clarity, the 431 is in addition to the required amount.
Okay, so that's clear. That's good. So, there's some debate in the development community regarding what the value of additional density is. So when you buy a piece of land, for example, you can typically reverse engineer the value of the density. Some use, up to 100 per door is a common metric in terms of something you might pay for some density. I don't need to belabor it. Some are going to disagree with that. I'm not here to give a lesson in development, but what I'm trying to illustrate is that we seem to be looking at a pretty significant amount of additional density, which has a significant value for which only for 431,000 is being offered. So this is pretty significant to me. And this highlights some of the challenges that we have around these kinds of specific applications, which I've raised significantly earlier in the council term. This ends up being a pretty significant giveaway to the developer. We end up with additional density in Willoughby that costs us money in terms of demand for parks, demand for recreation facilities, road infrastructure, the LEC expansion, and a number of other things. We end up having a lot of people that we didn't necessarily project in these community plans. And then people are essentially building this density, pocketing the profit. And in my opinion, there's nothing wrong with that. I'm pro-profit. I have no issues with that. But that we also need money to provide the capital expansion and infrastructure in our community. And so when we project something out at a relatively low density, and then we allow someone to upzone it to this degree with a relatively minor amount of CAC contributions, it ends up being a pretty significant giveaway to the development community. And we've been doing that for a long, long time. And there's a reason for that. We don't have a lot of CAC money to pay for things that our residents require and our residents should expect. And at some point, we need to stop doing that. So I would like to, and I was hoping to have more time to prepare this more fully, but one more point to add: when people purchase this land, they typically purchase it for the designation, and then come along and upzone it to this degree. I feel kind of sorry for whoever owned this land when it was required, because they certainly probably weren't told that it was going to be upzoned by 39 units. So I'd like to make a motion to refer this back to staff for a more appropriate community amenity contribution, more in line with the additional land value being created with this upside.
I'll second that referral.
Here's a referral on the table. I'd like to ask staff for the increased density. Do DCCs still apply to that? So the DCCs are used to, fund the roads and there's park DCCs or park amenity fees. That sort of thing. Does that increase aside from this 431 amenity?
That's correct, Your Worship. So the DCC would be applicable on each unit.
Okay, thank you. So there is money with increased density. That money does come back, same as it would for any development. So that just helps me. Thank you, Councilor
Very,
Whitmarsh.
very helpful, Mr. Mayor. Thank you so much for that.
Yeah, thank you. It's, you know, Councilor Woodward, we're all here to get information from staff. And I heard that it sounded to me when you were speaking, that was just the CACs that was coming, but there's also the DCCs that come along with the increased density. So
Which of course
that's
is
just one
factored
package.
into the
I'm not here to debate it. I just.
Well, you are
Thank you.
debating it. You're
Councilor
specifically
Whitmarsh?
projecting in the debate when you're not on the speakers list like the rest of them.
Councilor Woodward, I am on the speakers list. I set the speakers list. Thank you. Councilor Whitmarsh.
I'll note you down as having spoken once to the motion.
Councilor Woodward,
There.
I'd ask you to have a little more decorum.
Decorum is that
Thank
you
you.
don't put yourself on the speakers list like the rest of us. You interject in the debate.
Councilor Woodward, I can. Thank you.
Contradicting the points that others make. And you only do.
Councilor Woodward, I'd ask that you stop. Thank you. Next speaker is Councilor Whitmarsh.
Yeah, thank you. In follow-up to the point that Councilor Woodward was making, through your worship of staff, how is that 431 determined? Is there a formula that we're using to determine those increased density, or is it based on the original calculation for CACs, or is there something that we use differently for when we have increased density?
Through your worship to Councilor Whitmarsh, thank you for the question. In this instance and in another previous instance, council has supported what is represented there, which is 3 times the community amenity contribution per unit. So that number there will be 39 times the applicable townhouse community amenity contribution rate times the 39 units.
So is that something that is that sort of been standardized, that whenever people ask for density, we charge them 3 times the CAC rate for the additional density?
Through your worship, to Councilor Whitmarsh, there's been no specific council direction on that. Staff have worked with proponents to advance those items on that basis. And that to date is what council has elected to entertain in these specific instances, in the absence of some other more specific framework.
Okay, thank you.
Councilor Ferguson.
Thank you. Can you hear me?
Yes.
Okay. Because sometimes you can't hear me with these headphones on. I did want to say that through the chair to Mr. Richardson, this was a fairly large application with a lot of steps and a lot of requirements. To Mr. Richardson, how long since the very first time they met with staff, how would they have been proceeding with this particular application?
Through the chair to Councilor Ferguson, I haven't dedicated the application date to memory, so I don't have that offhand. My guess would be at least 1 year to get to this point, given some of the conversations I've been involved with the proponent.
Well, perhaps, if I may, perhaps longer than that. And I think over the last, if I gain to Mr. Richardson, over the last year and a half, there has been a serious increase in DCCs, both at our level, at the Metro Vancouver level. Is that correct, Mr. Richardson, which this proponent would indeed have to pay?
Through your worship to Councilor Ferguson, correct. There's a DCC increase on March the 31st of 2021, a deadline for applications that weren't in the rezoning process review. So there is a potential that the proponent could avail themselves of a lesser DCC amount if they were able to be considered an in-stream application and meet those requirements.
And if I may, last question, that is not going to change the fact that they'll still be required to pay CACs and other fees and charges, if I may.
Through your worship, Councilor Ferguson, that's correct.
Okay, thank you very much.
Thank you. I see no further discussion on the referral, so I'll call the question. All those in favor? And opposed? Got Mayor Froese, Councilor Arneson, Councilor Whitmarsh, Councilor Kuntz, Councilor Ferguson, and Councilor Long opposed. So referral fails. Back to the main motion. Councilor Woodward, your hand is still up. We wish to speak a second time.
Yeah, no, I'd like to speak again. Yeah.
Go ahead.
Okay, so I think this is something that we might have to look at, because I think there's it's pretty easy to create a lot of confusion, because just because you're paying DCCs on additional density doesn't mean that the significant increase in value is accruing almost solely to the landowner, which is again fine. But again, if we're not going to push this, and in terms of we're going to collect 5,000 or 10,000, 15,000 for density that's worth far in excess of that, then we're really doing a significant disservice to the Township of Langley taxpayers. It's beyond a comprehension that we continue to do this meeting after meeting and year after year, and then wonder why there's no money to build a performing arts center, why there's no money for additional ice rinks, and why there's no money for additional community centers. This is exactly why there's no more money and not enough money to build facilities in the Township of Langley for Township of Langley taxpayers. This is it right here. And this has been going on for years, and apparently will continue to go on even when it's brought up at the council table in a very reasonable way. I didn't specify a specific amount. I didn't try to create a formula on the fly. I didn't try to come up with anything specific. I asked for something more in line with the value that's being created here for the benefit of both the property owner and the development industry and the Township of Langley taxpayer, not solely to the benefit of one party. So I'll leave it there. And I think my frustration is pretty clear. This continues year after year after year. And then in the budget process, we'll start discovering again in 2021, just like 2018 and 2019 and 2015 and 2014, that there isn't sufficient funds to pay for the extra facilities that our residents need, residents that are here because of the development industry, making significant profits, while we continue to not accrue even a marginally acceptable benefit for the Township of Langley taxpayers as well. Thank you.
Thank you. Councilor Davis.
Thank you very much. I don't want to stick my head in the sand here. I think what Councillor Woodwards is saying, like I don't know if we can't pay for a performing arts center and all that sort of stuff, but I wonder if it's worthy to actually, maybe I need to educate myself more than anything to see where this is going. So I don't know what to say about that. I just, maybe the way it's coming out, but I would like to talk, at least have some sort of a report back, so that, because it's not in the financial, like on a public hearing like this, we don't get financial, by upzoning, and we've been upzoning a lot every time we do something in Willoughby, it gets upzoned. But maybe we should have just even a report back to seeing what is costing us in upzoning, if any, or if there is anything that's worthy, I think, of our time. Thank you.
Great, thank you. Okay, so with that, I'll call the question. All those in favor? And opposed?
Opposed.
I'm opposed.
Councillor Arneson, Councillor Richter, Councillor Woodward opposed. The motion carries. Thank you. So that the public hearing comes to an end. I'll ask for motion to terminate.
Sorry, Davis.
Councillor Davis is opposed. Okay, thank you.
Sorry.
Call the question. Or sorry, I need a motion to terminate.
Termination.
Councillor Davis moves termination. Second by Councillor Whitmarsh. All those in favor? Opposed? Carried. Thank you.